have Honorable Maria Milagros N. Fernan Cayosa, Honorable Jose V. Mejia, Honorable Justice Aurora Santiago Lagman, Honorable Justice Angelina Sandoval Gutierrez, Honorable Minardo I. Guevara, please remain standing for the centennial prayer for the courts, national anthem, and the Supreme Court hymn.
Almighty God, we stand in your holy presence as our Supreme Judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
Sa manlulubi, kita masisingil sa public interview of applicants for the position of Associate Justice of the Supreme Court to be vacated by Associate Justice Martin S. Villarama Jr. on January 16 this year is now declared open.
Your Honors, the candidates to be interviewed this morning are the following. We have Attorney Joe Santos B. Bisquera of the Bisquera Balagtas Law Center and Dean, University of Manila. Then we have Secretary of Justice Alfredo Benjamin S. Kagawa. Number 3, Sandigan Bayan Presiding Justice Amparo M. Cabotahitang. And Congresswoman Quinchona Cruz Gonzalez, CBAC Party List. May I request Secretary Kagawa, Presiding Justice Cabotahitang, and Congresswoman Gonzalez to stay in the holding room while the interview of Attorney Bisquera is being conducted. Thank you so much, sir. Attorney Bisquera, please occupy the hot seat.
Good morning po, Justice.
You are now ready for interview. So may I request Attorney Cayosa to start?
Thank you, Madam Chairman. Good morning. Good morning, Dean Bisquera.
Good morning po, ma'am.
In your personal data sheet, it states that you turned 68 last October 2015. May I know what made you decide to apply at this stage in your life for the position of Associate Justice of the Supreme Court?
Your Honor, I applied for the position of Associate Justice Supreme Court because I feel that my 45 years as a corporate business, senior business manager, and also my being a professor in the Graduate School of Business of both UP and De La Salle would introduce a new perspective, an additional perspective in the resolution of mercantile law cases and other business-related cases before the Supreme Court. So I feel that while I've been a perennial candidate here, and I remember you were already in the panel in 2012 when I sat here, I still feel mentally and physically strong to be able to contribute to the jurisprudence of the Supreme Court, especially in the areas of my expertise in the field of business and commerce.
Thank you, Dean. The Supreme Court has administrative supervision over all lower courts and the personnel. Could you be more specific? What would be your cause, or what would you hope to accomplish within less than 2 years should you be appointed, since the mandatory age of retirement is 70?
Your Honors, the major strategic issue on the judicial system in the Philippines revolves around the speedy disposition of justice. And without casting any aspersion on the ongoing efforts, because there have been major efforts to accelerate the judicial process, perhaps the Supreme Court needs a fresh look from somebody like me who's had 45 years in the private sector, especially specializing in the area of systems and procedures. In my own participation as a practitioner, I have seen 1,001 nooks and corners of slowing down of the process, and while almost all members of the Philippine bar, especially the practitioners and the judges and justice, can see it, there have not been any aggressive effort to smoothen the flow. And somehow my training and experience in the private sector using the concept of mapping and systems flow charting, and also the concept of accountabilities and information and control would be a significant contribution even for the short time that I may be in the Supreme Court, Your Honors.
I noted that you have been in the academe for quite some time. Could you specify a particular project or undertaking that you have successfully engaged in the academe, which would show that you do have the expertise to come up with a mapping system that would help improve in the administration of justice?
Your Honors, in the area of the academe, the application of mapping may be marginal. But I remember Justice Gutierrez was still active in the Supreme Court when I was appointed Dean of the College of Law of the University of Manila, who was about to lose its permit because of 4 years zero performance in the bar. On my second year, and it has not been overtaken, we have registered 75% passing in the bar, and everybody, including the Supreme Court justices, were kidding me and say, "Dean Bisquera, what miracle did you do for UM?" Up to now, Justice, that has not been matched. Unfortunately, I have not produced a bar top notcher from UM yet. It may happen somehow.
Thank you, Dean. Now, in your personal data sheet, you also disclosed that there was a bar discipline case filed against you in 2007
Yes, Your
by a
Honors.
certain Emmy Marahay. Could you
Yes.
tell us something about this case? I know that this has since been dismissed or decided,
Yes.
but perhaps you might want to inform us about the details. of
Yes,
this
Your
case.
Honor. Your Honor, this is a labor case where the employees of Motorola were retrenched, and there was a very crucial issue on whether, in spite of the 2 months for every year of service separation pay they were given, whether they're entitled to a vested fund that gives them an additional 1 month for every year of service. I fought this particular case up to the Supreme Court, and it is not only Ms. Marahay that filed a case. There were 4 others. Your Honors, it was a simple case when they didn't even want to pay the acceptance fee. My acceptance fee was essentially only 5,000. They paid me initially 500 with the commitment that they will pay the balance when I win the case. And I won the case after 7 years. These 5 people simply ran away with their proceeds. And when I was trying to collect, they went to the IBP to file a disbarment case against me, so they are not, they cannot pay. The Supreme Court, when it reached the Supreme Court, had a very complimentary decision saying Dean Bisquera gave his best opposite the biggest law firm in the Philippines, and he won the case on merits, and therefore a 5,000 acceptance fee where only 500 was given is heavily reasonable, and so the disbarment case has no meaning at all. This is the Supreme Court talking, Your Honors.
My final question, Dean Bisquera, in as much as in 2012 we extensively interviewed you, I just want to find out, what would be your legacy if given the opportunity to serve in the High Court?
Your Honor, I will be very candid in saying that I am a realistic person. I know that getting government positions is not purely on the basis of merits on the table. There are a lot of unmentionable factors that can happen. But if by chance of fate and the blessing of the Lord, I sit in the Supreme Court for 2 years, Your Honor, I'd like people to remember this was the fellow, the only certified public accountant that ever landed in the Supreme Court. And it was not only his title, he was the one who contributed to a smoother flow and fast disposition of cases. If that is the only thing that they will say when they put me 6 feet under the ground, I would probably be smiling, Your Honor.
With that, Dean Bisquera, as I mentioned, that was my last question.
Marami pong salamat.
Maraming salamat, and I wish you luck. Salamat po.
Thank you
Thank
so
you,
much,
Madam Chairman.
Attorney Cayosa. Thank you, Dean. May I request now Attorney Mejia to continue?
Thank you, Justice Gutierrez. Good morning, Dean Bisquera.
morning
Just
po.
a few questions, Dean Bisquera. Your PDS indicates that you are deeply involved in legal education.
Yes, Your Honor.
And how do you assess the current state of our legal education?
Your Honor, since I'm a strategic man from the business point of view, and I applied the analysis of strategy in relation to the law schools, it is to be candid about it. The law schools can be somehow cut off by way of saying UP, Ateneo, and San Beda, and probably just to make Justice Gutierrez a little more pleasant, let's include the University of Santo Tomas, where I also became a faculty member. I have a feeling, Your Honor, that the market is totally different because these 4 schools have full-time students with all the resources that they can afford. And one time when I asked one of the deans of these law schools on how I can improve, the lot of the University of Manila Law School said, "Dean, huwag mo nang ambisyonin na talunin kami because we get the best quality with all the resources. You get, essentially clerks in offices, government institutions, low-level police officers. And so if you can pass them on the first sitting in the bar, you have made your mission. You have allowed them to at least become good lawyers because they have the minimum. So forget about matching our capability at the Ateneo, at UP, San Beda, and UST. And I can only blink and say these are the realities of legal education in the Philippines. On the other hand, Your Honor, there's one little joke that I always get even when Justice Gutierrez was chairman of the bar examination. Your Honor, if you remember, they were kidding me about abolishing taxation because the biggest mortality, I guess, is mercantile taxation by statistics. And they were saying only Dean Bisquera knows how to teach taxation among the deans, so let's abolish taxation. But somehow along the line, these are some of the inconsistencies in the way we looked at the bar subjects. I was the first dean to support Justice Abad when he introduced the MCQ, the multiple choice methodology. I felt the working students have a greater chance because it eliminates the question of grammatical errors, poor handwriting, and so on. I don't know why there have been a slow return to the essay type because there was no intention to abandon the essay type, but a balancing of multiple choice questions and essay type. Final point, Your Honor, we have law professors who do not know how to teach. In the proliferation of green jokes and stories that are irrelevant to the subject continue to bug the law schools.
Thank you. On a related matter, should you have an opportunity, Dean Bisquera, to introduce innovations in the admission of law graduates to the bar, what would those innovations be? I like the idea that most states in the United States have now in place that the examination comes in 2 parts. Somehow it's essentially the MCQ on the first part to measure the minimum requirements, and it can be taken somehow in most of the states at the schedule of the candidate, and then the second half becomes the essay type. This may really help a lot of working law students because they will not be pressured to go into the bar review the way we are doing it right now. And so they can take the bar examinations at their own pace and still hope to pass the bar. By the way, Your Honor, I was a working student and I entered law school as an old man at 40 years old and took the bar one take. Disappointed because I did not land in the top 10. Okay, you mentioned that, your PDS also indicates that one of your areas of expertise is taxation.
Taxation, yes.
Are there any current policies of the BIR that you find legally questionable?
In terms of legal issues, Your Honor, candidly none. The 1997 amended income tax, the National Internal Revenue Code, plugged in a lot of loopholes that I'm very familiar with in terms especially of executive compensation. Let me share with you some of the inputs that we were doing. Meaning I was the beneficiary of that and it was legal. There was a time I was working with a big corporation and they said, okay, Joe, you have this compensation, but we'd like to increase it. We will only declare 40%,
60% of it, the 40% will pay to you some other way. You know what they did? They opened a credit card facility for me. They deposit the 40%. It's not subject to withholding tax. It is not even declared. And therefore, that kind of mechanism was spread all over the place. Fortunately, when the tax code was amended, they consulted one of the leading auditing firms in the Philippines, especially the retired CPA lawyer said, the president then, I will not mention his name, said, tulungan nyo naman ng bayan para mag-improve yung ating tax collection system. Yung tinip nila yung mga ganong mga tax evasion cases, which was not evasion at that time because the law did not prohibit that. Today, no more. So as a tax professor, when people ask me how do they save taxes, I said, you better pay your taxes correctly because the government needs the money that should come back to us. And there is no room for us to cheat the government this time.
Thank you. That was my final question.
Thank you,
Good luck, Dean Vizquera.
Thank you.
Madam
Thank you
Chairman.
so much, Attorney Mejia. May I request then our new member acting in an acting capacity representing the Secretary of Justice, Attorney Guevara,
Thank you,
to
Justice.
continue.
Thank you, Justice. Good morning, Dean.
Good morning po.
I had the opportunity last night to take a look at your personal data sheet. I'm sorry that much of the documents that were intended for this interview were delivered to me quite late in the day, but I took the evening to go over all the papers submitted, and knowing that you would be first, I took a look at your personal data sheet and noted some observations here. This would go way back to your educational background. I hope you don't mind.
No, I don't mind.
Yes, because I noticed that you graduated valedictorian from the University of the East in your Bachelor of Laws degree.
Yes, Your Honors.
Cum laude and valedictorian. And also from the same university, much earlier when you took up accounting, you graduated actually summa cum laude. And even got this award, Citizenship Award for outstanding performance in academics. However, I noted that when you took the bar exams, you obtained a rating of 76%. And when you took the CPA board exams, you got a rating of 77%. Considering the very high academic performance that you had while you were in the university, could you please explain to me this sudden downturn in your performance during the bar and the board exams?
Marami pong salamat for asking that question, sir. First of all, I always say that the Lord has a way of reaching out to you. And so I was expecting to be in the top 10 in both the CPA and bar exams, and I did not with those grades. And if you scan the grades, the subjects where I'm supposed to make a real showing is where somewhere along the line it didn't happen. My explanation, Justice, is this. The Lord is a way of reaching out to you and say, bawas-bawasan mo naman ang yabang mo. Lahat na ng klase ng honor binigay ko sa iyo. Pati ba naman yung CPA tsaka bar, magyayabang ka na naman. It allowed me to be a little more realistic that there are challenges in life where you cannot win all the time. That there are certain situations where you bow and say, that is it. Now, in the bar examination, what is amazing is I took the bar when I was 45 years old. And even my professors in the political science who became my mentors in the College of Law said, Dean, no, ikaw estudyante namin sa political science, plot 1 ka prelims, midterm finals. Pero that was 25 years ago. Nandyan pa ba ang utak mo? And I was smiling and said, Sir, subukan po natin. Opo. So that is the only, and my reaction is, in spite of this frustration, after the announcement of the bar was made, I think I'm the only new lawyer who became a bar reviewer immediately 3 months after my passing the bar. And this is against the objection of another lawyer, the president and owner of the University of Manila, who at that time threatened Dean Moralde to be fired if there is any single bar reviewee who will complain about anything that I do in the bar. Your Honor, I did not only continue to become a bar reviewer for years in many schools, I became the dean of that school in 2004. And when I was offered that, I reminded the president, said, weren't you objecting to my being even a law professor? And so he said, kalimutan mo na nga yun din, you have proven your worth. So to my mind, Your Honor, I submit with all humility, I did not succeed in my objective in the CPA and bar examination. And I accept that.
Thank you, Dean. It seems that you'll be turning 69 this year.
68 po ka lang, no, October.
Yes, so this year you'll be turning 69.
Sa October po.
Yes, that's right.
Please allow me to enjoy the benefit of the period.
Exactly. So, and you were saying earlier that within the less than 2-year period remaining, just in case you're appointed to the highest court of the land, you'll be able to contribute what you had gained during your 45 years of private law practice and legal education. So can you give us an idea by probably mentioning 3 specific measures that you could propose to speed up the civil litigation process?
I will bore the 3 members of the panel who were already here in 2012 when I mentioned this. There are a number of nooks and corners in our rules of court that we have already admitted to be redundant, and we continue to follow it. For example, Your Honor, in the rules of court, if a trial judge makes a decision, there is a need for us to file a motion for reconsideration in order for the action to continue. Without the motion for reconsideration, the next step, for example, on appellate jurisdiction will not happen. Your Honor, I wonder if we apply statistics of the 1,000 and a couple of thousands of trial judges in the Philippines, how many of them have reversed their decision on the basis of motion for reconsideration? Let's be very realistic about it. A judge is presumably somebody who studies the full details of his case and would not render a decision based on whimsical and an arbitrary basis, because he will be exposed to the ridicule and censure of the appellate courts up to the Supreme Court. And so it may be interesting to note that in my own practice, I have never won a reversal of a decision where I filed a motion for reconsideration. So one of the questions I'd like to raise is, what if we remove the motion for reconsideration, which we already did, or we have already done, in the cases of labor disputes? There is no MR on the arbiter's decision. And so we are already admitting that in the area of speed of execution, we can definitely improve the speed by just eliminating the MR, because the MR will call for a reply from the other party, and it really prolongs the process. And among smart practitioners, they make use of this precisely to tire the opposing party who may not have the financial resources for a prolonged trial. And so I would immediately move. Even now, I probably, with or without any result of this one, I will probably move to the Supreme Court to propose the amendment of the rules to eliminate all the MRs. Second point, Your Honor, and this is where the Chief Justice reacted when I mentioned this, and I wouldn't mind repeating this. We have 15 justices of the Supreme Court, and if we eliminate the Chief Justice, we have 14 justices up there. On the other hand, if you look at the hierarchy of courts, we have, of course, the appellate courts, and then we have the trial courts. My question is, why have we not organized the courts into a certain accountability, where out of the 14 judicial regions, we now make one justice of the Supreme Court fully accountable, with the complement of, who knows, 2 or 3 or 4 justices of the Court of Appeal. So you will have, for example, in Region 1, a complete hierarchy of justices, and therefore, if there are any of the unnecessary filing of appeals, certiorari's, and so on, these are initially screened within that particular regional responsibility. Now, the reaction I got was, Dean, the justices of the Supreme Court have already so much load, and I wanted to react, but in a public forum like this, you don't argue with the Chief Justice. And so I kept my mouth shut, but may I be allowed now to speak and say, probably it's like the question of the chicken or the egg. The reason why so many cases go up to the Supreme Court is because we don't have the screening process and accountabilities from a Chief Justice, from a Associate Justice of the Supreme Court, accountable for a region, complemented by certain designated Court of Appeals justices. And now we make sense in appointing executive judges of the regional trial courts and metropolitan trial courts. There's going to be a team that will be accountable, and the measurement of the disposition and quality of the decisions within a certain structure. We don't have the structure right now, Your Honors. And if this causes me my not even being voted upon by any of you, I surrender. But I will not rest this case until somebody realizes that that is how the management ball game is played in the private sector. Everybody is accountable for everybody, and the monitoring of performance is closely within the area of responsibility centers.
Thank you, Dean.
Thank you so much, Attorney Guevara. And now may I request Justice Lagman to continue.
Thank you very much, Justice Gutierrez, Attorney Santos Balagtas. Good morning.
Good morning po.
Now, as you have stated before and as shown by our records, we have extensively interviewed you on October 23, 2012 in connection with your application also for a slot in the Supreme Court. So I have a very few questions now. Attorney Santos, how is your health? We do not have any record of your latest medical certificate.
Your Honor, I am a triple bypass survivor 7 years ago.
Yes.
And the doctor said, Dean, the cycle is 5 years, 5 years. So I'm running on my second year on the extra period.
Yes.
And I'm not, I have not had any signal from my cardiologist. I will have to go to another cycle of bypass operations. In fact, Your Honor, this is one of the monuments in the way I care for myself. At the age of 35, I was discovered to have a arterial block in my aorta.
Okay.
And in medical parlance, that would have given me only 5 to 10 years to live.
Okay.
Aorta, as you know, is the entry point for the blood to enter the heart. Your Honor, I took care of myself for 2 years. I was able to do a lot of things, even using statistical measurements and graphs. And on my second year, which I was 37, I underwent my second executive checkup. And surprisingly, I passed the treadmill test.
Okay.
And when I was looked into, even my cardiologist, a Tomasian doctor who was the first woman president of the Philippine Heart Association, said, I don't believe this. How can you ever pass a treadmill when you have that problem? You know, about a couple of years after that, I again underwent examination at the Makati Medical. They did not find the block in the heart.
Okay.
And so when I was bypassed in 61, the cardiologist said, are you still alive, Dean? Because at 35 years. Today, Your Honor, I'm running on borrowed time. And so if you ask me how is my health, I still feel good. My medications are okay. I exercise. I cut down on the eating during the Christmas holidays. I have not gained much weight. So I think, Your Honor, I am as healthy as anybody of my age.
Okay. as you have stated, you are running on borrowed time because of your heart condition. Do you think your heart can survive the pressure which you will surely encounter if you will be fortunate to be nominated and appointed as a member of the highest court of the land?
Your Honor, very, very interesting question about stress management.
Okay.
I learned at an early stage that managing stress is really using your brain and your system. If in a stressful situation, like this is a stressful situation, the real technique here is to scale stress in a scale of 1 to 10. And when you reach the level where feeling 5 or 6 already, you should simply say, hey, relax, relax, stop the stress. Now, if you say that the practice of law and in the Supreme Court there is stress, Your Honor, let me just share with you that the private sector stress is worse because the pressure, especially on my part as Chief Finance Officer, to meet payroll, to pay suppliers, and all of these stresses has been a bread and butter for me. And yet, in those 45 years that I was subjected to stress in the private sector, I was myself a practicing lawyer appearing in court. And I was also teaching at the College of Law. I was also teaching in the graduate school. So the multitasking, Your Honor, has always been there. And so I guess stress has been part of me. I can survive the stress.
I see. That's a good outlook. Okay. Now, I also observe that you are so active and very vigilant in the workings in the Supreme Court. No. Now, in certain cases, there have been conflicting rulings and views made by the Supreme Court. As a long-time practitioner, what would you suggest to avoid such conflicting rulings and views?
Your Honor, this is a matter of managing the database of cases, because we know that many cases have already been resolved, and the Supreme Court and the rules of court have built-in checks and balances, in that if, for example, a certain legal concept has been adopted in a decision, it is expected that that becomes the jurisprudence in that specific subject matter. Now, so that if there is another division that would make a decision, it is fundamental in our rules of court that these particular decisions have been reconciled. In fairness to the divisions of the Supreme Court, it is possible that an identical issue is presented, for example, to the third division, and after a few days, the same issues but involving different parties is presented to the second division. Because the divisions really are autonomous in their own right. It is possible that the decisions there may run into conflict. And the funny thing is it may even run with existing jurisprudence. There is a need for administrative management here. This is what I was saying. If you come from the private sector, that cannot happen because you cannot have a program of promoting, for example, Tide or for example, Ariel. And on the other hand, your sales force is promoting another thing. That is mortal sin in the private sector management. It's a unity of command and focus on decisions. But I hate to say this. I always encounter situations, and I'm very fond of research, where you see two decisions that are definitely conflicting. They are recent decisions, and it can be shocking, and sometimes you lose out. Now, the funny thing about practitioners is they will cite the decision that favors their case, and would probably remain silent about the other decision that does not favor the case, when the real honest move is to elevate the issue before the Supreme Court and highlight that there are these decisions. So, in answer, how do you manage this? There has to be a management control system that screens off these conflicting views.
Okay, this will be my last question. Attorney Santos, what do you consider as your strength and weakness, both as a person and as a member of the legal profession?
My major strength, Your Honor, is the wealth of experience I got from it being in the private sector. And this is also tied up with the weakness that was already asked of me in 2012. Dean, you have never been part of the judiciary, so how do you expect to perform well as an Associate Justice of the Supreme Court? Let me combine this and say this is essentially a strength by its own right. Because if we have a battery of experts as trial judges that went up the ladder, essentially we're talking about a homogeneous set of associate justices who are seasoned with the procedural aspect of getting the cases flowing. Of course, I'm not questioning their expertise on substantive law. But if you bring in somebody who's totally not tied up to that system, I come from the private sector with varied industries: petroleum, energy, agriculture, pharmaceuticals, and electronics. And so if the objective is to speed up the cases, judges and justices who do not have their exposure on these industries will have to call on a lot of consultants. I can eliminate all of those because I already have the wealth of knowledge and experience. So this, even the in-workings, even on corporate law, I don't have to read the cases. The cases are available, but I know how the workings are inside, even the backdoor maneuvers in corporations. So I will understand, a lot of these cases that are presented. Now, why do we have a bottleneck of cases? If you look at even the trial court level, up to the Court of Appeals and Supreme Court, the accumulation of cases understandably will zero in on the areas where the judges and justices have no expertise. And so, what are these? These are essentially the mercantile law and commercial law cases that are not very easy to understand, from corporation law to banking, which is a specialization, to transportation, to insurance. I bring with me 45 years of tested knowledge, working knowledge, in that I don't even have to study the industries anymore. I bring in and say, this is how the industry works, this is the conflict, this is how it is. And probably it's a collegial body. I will explain to the other 4 members, ganito po yung kilitian dyan eh. And so, there is no need to bring in any consultant because the other justices can verify whether I'm bluffing my way out on this one. So I carry with that kind of strength, Your Honor. Not to mention that this has been tested in the graduate schools of UP and LaSalle, where I've been teaching in UP 10 years, at LaSalle about 40 years. Thank you.
Question, and I wish you luck, Attorney Biscayne.
Marami pong salamat.
Thank you very much.
Ma'am, you said that in 2012 and I didn't get the luck, so I hope you say it better this time.
So thank you very much, Justice Lagman. And now it's my turn.
You know, it's a privilege to meet you again.
Okay. Dean, what took you so long before applying for the position of Associate Justice of the Supreme Court? Why only now?
Your Honor, I was heavily considered in 2012.
How many years ago? That was all. And what was your age then?
I'm 68 now, minus 65.
Why not when you were at 50, 55, or before 60?
Because, Your Honor, I passed the bar when I was 47. And after I reached the 5-year experience as a lawyer, the records of the JBC will affirm to this. I have been applying consistently for all the legal positions available.
At 57, you could have made a try. Anyway, I admire your proposed measures to dispose of cases with dispatch. But I think time is of the essence. You know, it is a fact, because I came from the Supreme Court, that although you are well-versed in all laws, procedures, jurisprudence, but the inner workings in the Supreme Court are really different. And sometimes it takes 1 year or more for a new member to learn the ropes.
Yes.
So don't you think your time is limited, just in case you are lucky enough to be there?
Your Honor, I have experienced the same scenario in all the companies I've joined. Because when you come in at the senior level, even the subordinate...
That is very, very different from the scenario I'm laying before you.
Posible po.
So,
Posible po, Justice.
napakahirap na po
Posible po.
at your age.
Posible
But
po.
anyway, if you are lucky enough, let us see. Okay, you stated that one of the measures you are proposing is to get away with MRs or motion for reconsideration.
Yes, Your Honor.
The Supreme Court, even when I was an MTC judge in Manila, had already promulgated a rule
Yes.
as far as the rule on summary procedure is concerned.
Yes.
MRs are
Yes.
prohibited.
Are prohibited.
But sometimes at the level of the RTC, it's so difficult to get rid of MRs because
Yes.
sometimes MRs have merits.
Yes.
MRs have merits.
Yes.
So we cannot absolutely eradicate MRs
Yes.
as far as I'm
I
concerned.
submit to that, Your Honor.
Okay. Anyway,
Your Honor, my only side comment on that is, perhaps this is where statistics will come in.
Okay.
That if we run the cases that have been subjected to MR, how many, what's the percent of reversal of a judge decision that was subjected to an MR? And that would, facts would always speak for themselves, And mathematics will not lie if we run this particular system.
even during the time of Chief Justice Fernan,
Yes.
the Supreme Court had been promulgating rules
Yes.
to these post cases
Yes.
early. But then, will you agree with me that despite all the rules the Supreme Court has been issuing until now, still there is delay in the disposition of cases
Yes.
from the highest to the lowest level?
Yes.
And one of the reasons is, you know why?
No, Your Honor.
The personality of the judges themselves, if they are lazy, no amount
I
of
submit to that, Your
arguing,
Honor.
no number of rules, can move them.
Yes.
So what is important is the support of the Supreme Court to see to it that justices being appointed are highly efficient, dedicated. Okay.
I can continue to hear Justice Gutierrez, whom I have heard repeatedly in the past, and you're still the same person, Your Honor.
Thank you. Anyway, just recently, the Supreme Court promulgated its decision concerning the case of Senator Enrile.
Yes.
If you were a member of the Supreme Court, will you concur or dissent?
To allow Senator Enrile to post bail, is that?
Yes,
is
that was the
question?
ruling.
Yes. To be candid about it, I am bothered by the issue that has been brought to media on selective justice. What is fair for, in other words, I continue to believe on the personal.
Just answer my question then.
Yes.
Will you concur or dissent and then reason out?
I will dissent.
Why?
On the very principle that just because he is a special person, he should not be given a special treatment. He should be subjected to the same rules as, especially to the two other senators who are inside. And age should not be a consideration, Your Honor.
What else?
We already know the entitlement to bail is subject to conditions that it is bailable or not, and second, the degree of what you call this culpability, meaning the evidence is strong for conviction.
Do you think there was a defect in the procedure considering that there was yet no hearing before the Sandigan Bayan? The prosecution hasn't presented its case against him. Will not be that a ground for your dissent? Number two, don't you think the Supreme Court was not legislating, considering that actually it changes the provision of the Constitution that all persons are entitled to bail except those
Yes.
charged with an offense
non-bailable offenses and the evidence of
punishable by
guilt.
reclusion perpetua,
Yes.
and the evidence of guilt is strong.
Yes.
Now the Supreme Court laid how many grounds? Humanitarian reasons, old age.
Yes. Your Honor, I have read through the.
So when you dissent,
Yes.
just in case you reach the Supreme Court,
Yes.
make a wholesome some, reasoning.
Unfortunately for this question, Your Honor, the dissenting opinion which I am expressing is that of Justice Leonen, who happens to be in the same panel in 2012, and he was the one chosen. So probably if I were the one chosen, there will still be perhaps the same dissent.
You could have raised other issues. Okay.
Yes.
Another question. If you are asked by the Supreme Court, if you are already a member there, if you are lucky enough, to recommend amendments of Article 8 of the Constitution on the judiciary. Remember, Article 8 pertains to the judiciary of our present Constitution. What amendments will you propose?
I mentioned already one in terms of the structure of the judiciary, Your Honor. I would like to have a clearer organizational line which are organized from the Supreme Court up to the level of the Metropolitan Trial Courts, where there will be vertical accountabilities. And so when we talk about the system of, because people always generalize the system of justice in the Philippines, very slow, unfairness, and so on, it becomes a generalized motherhood statement. To allow that to be more specific so that corrective measures can be done, let an associate justice of the Supreme Court to be accountable on each of the 14 regions and down to the
That
Court
is
of
not
Appeals.
part of the amendment of the Constitution. That is a part of the rules.
Pwede po, Your Honor.
Hindi, rules
Hindi
yan.
po.
Hindi
Pwede pong
sa
rules,
Constitution. My question is constitutional amendment. How about fiscal autonomy?
Yun po yung area ko kasi ako yung financeman eh.
So, on that point,
medyo
what
hirap.
will be your proposed amendment?
One of the proposed amendments is I do agree that the judiciary should have total fiscal independence. And so in the matter of the charging of docket fees and all the incidentals relating to management of cases, the budget department of the executive department should never interfere because they are co-equal branches of government, and the judiciary should be given absolute power in terms of its managing its financial affairs, Your Honor.
So the judiciary does not have to kneel before the COA, before the DBM.
The Commission on Audit, Your Honor, would zero
No,
in.
DBM.
The DBM, I would like to take an exception that the DBM should not encroach on the funds of the judiciary. In other words, the Supreme Court and the rest of the courts can develop their own budget and as envisioned, submit it to Congress and therefore allow that the detailed budgeting to be admitted as a presumption of good management and good faith on the part of the judicial process, of the judicial department. But to ration off the funds for the judiciary by the DBM is totally an insult to an independent branch of government. I don't definitely agree with the way it's being run right now, Your Honor.
Of course, there is a constitutional provision for
Yes.
that. But in practice, as of now, there has not been an
Yes.
absolute
Yes.
fiscal autonomy on the part of the Supreme Court. I'm sorry, but the warning is there. So thank you very much. Din.
Your Honor, nakakahiya nga po kuminsan sa trial law, no? You go to the courts. My first few years of practice, I went into a court in Binyan, and it was so dilapidated. It's not the same now, but there was a time when we were hearing and dogs were crossing the court like that because it was really a dilapidated.
Even the Manila courts are dilapidated.
Opo.
Thank you so much, Dean. Good luck.
Ma'am, can I just make a closing statement here? I am realistic in saying that 16 candidates for one position is very tough for me, especially to be blunt about it. I don't have political backing here. I don't have anybody backing me up, talking to anyone of the powers that be. As a question of my 2 years available, let me offer an alternative. I have been applying for a lot of positions in the Judicial Department, and I have not been given the opportunity to even be a judge. So as an alternative, Your Honor, instead of just simply setting aside my papers, is it possible for me to offer my services at the trial court level? Give me the most problematic trial court in Manila, and I will submit a commitment that if I cannot move fast those cases in 1 year, then consider my resignation accepted. That's the only thing I'd like to do, just to prove that I mean something in terms of accelerating the judicial process. Yun lang po. Just in case, sayang naman po yung papel na yan, maraming mabibigat na candidates, baka naman sakali. Okay na po siguro, kahit na hindi na Associate Justice, pagtsatsagaan nyo na ako, kahit na trial court. And then, ma'am, you can watch me kasi matagal nyo lang kilala si Din, kakantsawan nyo lang ako, Din, puro pambobola ka, mag-resign ka na, wala kang managagawa. I will accept that, Your Honor. Maraming po salamat for your
Thank you, Dean.
consideration.
That's noted, and we'll place that on record.
Thank you. Am I done? Maraming po salamat for your time and your good questions.
To everybody.
So I know you are now ready for interview, so we'll start.
Yes, ma'am.
May I request Attorney Cayosa, please.
Thank you, Madam Chairman. Good morning, Secretary Kagawa.
Morning.
It states on record that you have been in the private practice of law for the past 27 years. What made you decide to give up your flourishing private practice and join public service in 2013?
A call of duty, and the fact that the president asked me to join him, and I couldn't refuse him.
At the time, you know that the current administration will be stepping down in June, and you know that there will be a limit. But then, if you do join the judiciary, that will be until age of 70.
That's correct.
And wouldn't this be a major sacrifice on your part financially?
Yes, it would.
Because it is indicated in your SALN that there was a tremendous drop from your net worth from 2013 to 2014.
Yes. How do I say this? I'm at that point in my life where I'm just listening to where God wants me to go. So that's where I am.
You could have applied for other judicial positions, but why the position of Associate Justice of the Supreme Court?
Like I said, I'm on this personal journey of trying to contribute as much as I can, and I've assessed myself, and I've looked at myself, and I've said, I think I have some things to contribute to the Supreme Court.
I had the occasion to look at the Department of Justice website, and something caught my eye. In the profile on you, it indicates that you were listed as chambers and partners as, and I quote, a leading Philippine lawyer in dispute resolution for the years 2010 and 2011. I wonder why this was stated in your website, and what is the significance of this listing?
I'm also surprised why it's there. That's probably just taken from my website when I was a private practitioner, so it's in my curriculum vitae. So I will make sure it's taken out now, because that's not relevant. Yeah.
But is it true that you have expertise in dispute resolution?
I would like to think so.
Should you become a member of the High Court, how will you utilize this expertise in alternative dispute resolution in order to improve the justice system in the country?
Well, I don't have any specifics. I would think that the first order of business for me, if I become Justice of the Supreme Court, is to find out the specific problems that beset the judiciary, whether at the first level, second level, or the Supreme Court level. At the end of the day, I think the expertise, if I may call it that one generates from the practice of arbitration cases is merely an expertise in having a broader understanding of the workings of any institution. In arbitration, unlike litigation, there's a broader appreciation of the issues and how these issues can be resolved, whether or not they're just by pure litigation or by other means.
Thank you, Mr. Secretary. Moving on to another item that you stated in your personal data sheet. There is this case filed by Attorney Sabino Acut, Martin Pison, and Paul Arias, filed sometime in 1999 for disbarment. It has since been dismissed, but could you tell us something about this case?
It's so way back. I think I was litigating on behalf of a Taiwanese bank, and those lawyers. Oh, okay, I think I remember a little bit. In that particular case, those lawyers acting on behalf of their clients were able to secure a writ of detention of an aircraft that was at that time in Taiwan, and because of that, I think my client filed a disbarment case against these three lawyers because they filed criminal cases against him for theft. I'm sorry, but it's really, really way back. But in retaliation for filing that disbarment case by this client of mine, they filed one against me. So, and it had something to do with the writ of sequestration that was issued by the Taiwanese court, and they were alleging that I had made a material misrepresentation in the affidavit that I prepared for the Chinese client. I'm sorry, ma'am, but it's really a long time ago.
And well, we just got information from the Office of the Bar Confident that the case has been dismissed.
Yes, it has.
Anyway, a few days ago, we received a letter from a certain Ricardo Benamir. Are you familiar with this person?
No, ma'am.
It's actually a verified letter saying some things about the orders that you have issued as a department secretary. And since you have not, I suppose, not been given yet a copy of this letter?
I was informed about the letter yesterday afternoon, and I think there's a covering note from the JBC that gives me 5 days to reply to that letter, and I will so reply to that letter.
May I just read portions of that letter to give you an opportunity to make a comment, a verbal comment to the allegations stated in the letter. And I quote, apparently DOJ Department Order number 911 is a continuation of a previous department order, DOJ Department Order number 902, which temporarily designated Associate Commissioner Repiso as Commissioner in charge of the Bureau's border control operations during the APEC meeting. In the last paragraph of the letter, it states that, and I quote, apparently to make Associate Commissioner Repiso the de facto commissioner despite the incumbency of Commissioner Mizon, taint his very competence to apply the law and administer justice with the integrity and fairness expected from a member of the highest court of the land, end of quote. Would you care to comment?
I have to read the specifics of what he says in his letter. I guess what I can tell you is that whatever department orders I have issued in the best interests of the department and in utmost good faith. No? There were reasons I did that, and there are certain reasons I do not want to disclose before this body for confidential reasons. But as a secretary of the department, and the immigration is a bureau under the department, I have supervision and control over what transpires in those bureaus. And in the exercise of my judgment and discretion, I issue those department orders.
There is a comment, and if I may also just quote, stating that should you be appointed to the High Court, you shall serve to protect the interests of the outgoing administration. How would you respond to that?
My father was a judge for 12 years. I know exactly how the judicial mind thinks. And I know that as a judge, I will wear a different hat, an altogether different hat. And in the discharge of my functions as a judge, I know that I will be confined to what the facts are and what the law is. So whoever made that comment can rest assured that there is no bias nor inclination towards anything in the face of whatever facts are presented before me and whatever law I know to apply.
Thank you, Mr. Secretary. That was my last question, and I wish you well.
Thank you.
Thank you, Madam Chairman. I have no further questions.
Thank you so much, Attorney Cayosa. May I request now Attorney Mejia to continue?
Thank you, Madam Chairman. Good morning, Secretary Kagawa. What is your greatest frustration as a lawyer?
That things moved very slow, that there were a lot of cases where I was involved where the merits didn't come into play, but other matters came into play. I think to any lawyer who practices law in the Philippines, that would be the greatest frustration, and not be in a position to change it.
In law school, one of the first orders of the day, so to speak, is for members of fraternities to recruit you into their fold. I noticed that you're not a member of any fraternity. What is your reason why you did not decide to become one?
Well, like you said, I'm a barbarian. I have no loyalties or affinities to these groups, and precisely, in fact, as you very well know, I became part of a group that tried to entice people away from fraternities. Because in my view then, and as it is my view now, fraternities create relationships that are above the law. And therefore, to me personally, I don't believe in them, and I think they're bad. No? So that's principally the reason I didn't join.
As the current DOJ Secretary, what are the most pressing problems being faced by the department today, and how are you addressing this?
The biggest problem that came to my attention early on was the lack of prosecutors. For one reason or another, the list of prosecutors that had been transmitted to the President had been returned to the Office of the Secretary of Justice for my take. And we tried to fast track that as possible, and we have done so, and it's now again with the President, and if I'm not mistaken, he has already taken active steps to address that problem. I visited regions 7 and 8, I think just before Christmas, just to find out exactly the problems on the ground as far as the regional offices of the DOJ are concerned. And lo and behold, exactly what we feared. No? We have prosecutors who have to do everything, no? They're the investigating prosecutors, they're the inquest fiscals, then they're the trial prosecutor, and then they have to travel to 4 different courts because there are no other prosecutors in that area. The sheer lack of personnel in the DOJ, I think, is the number one problem that's besetting the department.
In his column, this is related to the initial question of Attorney Cayosa. Dean Tony Lavinia of the Manila Standard stated that department orders numbers 911 and 912 that you have issued are unconstitutional and ultra vires. Can you just briefly comment on that?
I saw that article, and if you notice, he doesn't mention which provision of the Constitution I violated. I stand by my orders. Again, going back, I'm the alter ego of the President, and therefore, we're in the executive department, and everybody serves at the pleasure of the executive, which is the President. So I still believe, and I firmly believe, and I will defend myself against that letter, that those department orders are valid and correct.
That was my final question. Thank you and good luck, Secretary Kagawa. Thank you, Madam Chairman.
Thank you.
Thank you so much, Attorney Mejia. May I request now Attorney Guevara to continue?
Thank you, Justice. Good morning, Secretary Ben.
Good morning.
I'd like to bring you back to more than 30 years ago when we took the 1985 bar examinations.
Where you landed number 2, sir?
Do you remember still the very first question in our bar exams on the first Sunday in political law? You don't remember that question anymore?
I remember political law as one of the subjects then that I thought was so difficult because it was asking us to quote constitutional provisions. But I don't remember that specific first question.
Anyway, the very first question in that bar exams was, do you agree with the statement that the judicial branch is the weakest branch of government? I'd like to know your answer to that bar exam question, and also I'd like to find out whether you maintain up to the present whatever your answer to that question was in 1985.
I really don't remember my answer to that question. But I can answer you from what I have accumulated by way of experiences in the private sector and in the public sector. In the sense that the executive touches the lives of the everyday Filipinos in a more immediate and in a more tangible way. In that sense, my appreciation is that it is the executive that has the most tremendous power, and the power of the judiciary does not compare. But in the sense that there must be somebody who would curb the excesses or the mistakes or the acts of despotism of the executive, and that is the judiciary under our system of government. And I would, in that sense, say that the judiciary is even more powerful than the executive. So I guess it's really in what sense you appreciate the question.
Thank you, Secretary. I just have one more question. You're, of course, aware about the ongoing arbitration case between the Philippines and China,
Yes.
regarding the West Philippine Sea.
Yes.
And as you very well know, this matter is now submitted for decision of the Permanent Court of Arbitration at The Hague.
Yes.
All right. Should the Philippine government or the Philippines win that case, and the tribunal state that in fact China has violated the maritime entitlements of the Philippines, how do you think that judgment could be enforced?
I think that's a question that's always in our minds. I think the reason why the arbitration was initiated was not so much to be able to have a piece of paper that we can enforce. It was more as a rally point for everybody who believes in the rule of law, who believes in the treaties that countries enter into, namely the United Nations Convention on the Law of the Sea, to see and to exhibit to the whole world that the Philippines, as weak as it is, stands by the might of the law. No? And that's a question, again, I will have to discuss with the President when we win. How do we, in fact, enforce this thing in the normal sense of the word enforcement? But I think its biggest enforcement is on a practical level, is that we are able to how do you say this, empower the rest of the small countries to recognize that the rule of law, in this case the treaties, would be the one thing that will equalize things for a weak country versus a strong country. I'm talking economic and military.
Thank you, Mr. Secretary. I have no further questions.
Thank you.
Thank you so much, Attorney Guevara. And now may I request Justice Lagman to continue with the public interview.
Thank you very much, Madam Chair. Secretary, good morning.
Good morning, ma'am.
You are now the Secretary of Justice. How would you describe yourself in that position?
Good question. I recognize the powers that come with the office, and they're vast, they're huge, and therefore I realize the big responsibility that goes with those powers. For me, as just following up on what I had mentioned earlier about my greatest frustration, now I find myself in a situation where, in fact, I'm in a position to do good, no? To dispense justice in the parameters of the DOJ. And that's where I am, ma'am. Trying to find the ways I can wield the powers of the office towards the betterment of the normal Filipino. And it can be in a simple review of a petition for review, a simple disposition of a petition for review. It can be in empowering all the prosecutors all over the country by giving them better facilities. Because the second biggest problem of the Department of Justice is that the lack of facilities. Like I said, I went to Region 7 and 8, and if you go to the City Prosecutor's Office and Provincial Prosecutor's Office of Cebu, they stay in a place that is, it's not fit for office work. So one of the bigger things I'm doing right now, or I'm trying to do right now, is to find a way to address that physical problem, and hopefully I will find an immediate solution to all of these things. But again, sorry, going back, I digress. No? But going back to what you were saying, ma'am, with the vast powers that go with the office, for me, it's an opportunity to contribute towards good. As simple as I can put it.
Okay. In that line, Mr. Secretary, what are you doing, or what are your plans to improve the accessibility to justice of the poor and inadequately educated members of our society?
There are a number of programs that are currently ongoing in the DOJ. One of those programs is the IACAT. This is against trafficking of women.
Okay.
And I've seen the passion of the people in IACAT to protect our people. And I've seen as well that they are lacking in resources, they're lacking in adequate space, because they're located in different ports, they're located in different airports, and right now the first order of business again is a physical thing. No? We have to provide the correct office space as mundane as that, no, for those things. When I got appointed in October, ma'am, I knew that I only had 8 months, and therefore I couldn't come up with any grand plan for the DOJ. So it was a matter of prioritizing the existing programs of the DOJ, fine-tuning them so that in the next 8 months, at least while I'm there, I'm able to make things more efficient and therefore, again, directly address the needs of the normal Filipino.
Okay, let's go to another point, Secretary. Independence is one of the major attributes required by the Constitution for those who want to enter the judiciary.
Yes, ma'am.
Can you tell us your thoughts on judicial independence?
Judicial independence is to be impervious to any kind of influence, whether it's monetary, it's filial, or any kind. Again, I go back to what I was saying, that the primary duty of a judge is to resolve a controversy on the basis of the facts and the evidence, applying the law the way he understands the law. If a judge does that purely, then I assure you, he is already independent.
And how would you reconcile this with the Filipino culture or mentality of utang na loob? Will the appointee, for example, be forever indebted to the appointing authority?
That's a cultural question that I think will bedevil all of us for the
Yes.
next generation or so.
Yes, I just want to know your thoughts on that.
My thought there is a matter of understanding what your role is. In the executive, I know my role, which is to implement the law. In the judiciary, I know I will be wearing a different hat. And that hat and all the learnings I've had as a lawyer tell me that I'm not supposed to have any utang na loob to anybody.
Okay. Now, Secretary, you have been a private law practitioner for 27 years and Chief Presidential Legal Counsel and now Secretary of Justice, which positions involve interacting with people.
Yes, ma'am.
Now, if you will be fortunate to be nominated and appointed as a member of the Supreme Court, considering that your the former positions which you held, you were constantly interacting in that former positions, you were constantly interacting with people. Now, in the Supreme Court, most of the time, although not all the time, you will be confined in the four walls of your office, writing decisions and resolutions. Under that situation, do you think you can be an effective member of the court?
I think so, ma'am. At the end of the day, I go back to who I am. Hindi naman ako mabarkadang tao. And the only thing that's important to me right now is my family. So whatever dealings I may have had in those different positions, they were just professional dealings. When I start wearing the hat, if I'm fortunate enough to be appointed, if I start wearing that hat, I know exactly what that means. It means a change in my lifestyle. It means I will lead a more isolated life, but I'm fine with that. I'm fine with that because I have my family.
Okay. Considering that answer, Secretary, what do you treasure most in your life?
My family.
Okay, that's a good answer. Now, this is my last question.
Yes, ma'am.
In case you're appointed to the Supreme Court, do you think your lack of judicial background or experience would be a setback or a handicap in the effective and efficient performance of your work as a member of the highest court of the land?
Not at all, ma'am. I think as lawyers, we're all lawyers. We're all trained in a certain way. we're all taught how to critically think.
Yeah.
And my not having gone through the MTC, RTC, or Court of Appeals route does not mean, and I don't think it does, that I have a disability in performing a judicial function. At the end of the day, I think we're all taught the same law. We're all taught the same way of thinking and meaning. And by that I mean, as a judge, you resolve on the basis of law and the evidence before you. So, as a lawyer, I knew that very well. And therefore, when I was a trial lawyer for most of my life as a private practitioner, and therefore I knew what evidence to present, how to present it, so that I achieved my hurdle of convincing the judge to rule in my favor. Those are the very same skills, that's the very same mindset that the judge ought to have.
Okay. Although that's my last question.
Yes, ma'am.
We received a Twitter question for you, specifically for you, and I will like to read it. To SOJ Kagawa. Is it true that he recalled the appointments endorsed by ex-SOJ De Lima?
Sorry,
If
ma'am.
it's true, why?
I don't understand the question, ma'am.
This is not my question. This is sent. We received this by a certain El Mitanyo, and this is a Twitter question. He is asking, basically, if you have recalled any appointment endorsed by then Secretary De Lima in the DOJ.
Appointment? Ma'am, I don't recall.
No.
No.
So, okay, on that note, you have answered the question.
Thank you, ma'am.
Thank you very much, Secretary, and good luck.
Thank you.
Thank you so much, Justice Lagman.
Ma'am.
So, good morning again, Mr.
Morning.
Secretary. I believe you are a worthy son of a worthy father,
Thank you.
who was my professor in civil law and a recognized authority in civil law. But the question is, why did you not update his book on civil law?
Would you believe, ma'am, that that's exactly what I intend to do in the next 3 years of my life, to update my father's book.
In the next 3 years,
Well-
you will be loaded, supposing you are in the Supreme Court,
That's
with
why-
volumes and volumes of work.
I have a lot
Maybe
of...
you can do that upon retirement.
No, ma'am, I have a lot of really good researchers. They can help me.
Oh, okay.
Yes, yes.
So these twin questions are follow-up questions to the questions of Attorney Mejia.
Yes.
We stated a while ago that your problem as a practitioner was the slow pace of litigation. But who is to be blamed? The judiciary, the judges?
No, I think it's an amalgamation of reasons. Lawyers certainly are to be
I believe you. Lawyers should be blamed. You know why? They abuse
Yes.
Rule 65 especially. For every order of a trial judge, a lawyer will always go up to the Court of Appeals, then to the Supreme Court. And it takes years and years
Yes, ma'am.
before this incident could be resolved.
That's correct.
So do you think the Supreme Court, I've been urging the Supreme Court to do this when I was there, should issue a rule punishing lawyers who goes up to the Court of Appeals and the Supreme Court for frivolous petitions or appeals. In America, they are being punished criminally and with fine. What is your thought about this?
I think I completely agree with you that they should in fact be punished. Although I'm not going to go as far as a criminal charge, ma'am.
They should.
But a hefty fine should be sufficient.
So they will learn their lesson.
Yes.
Lawyers are the primary reasons why there is always delay in the disposition of cases. And sadly, it's always the judiciary being blamed, especially by the media. Okay, going to the second problem, lack of prosecutors.
Yes, ma'am.
You know, Mr. Secretary, the reason why? Your prosecutors have been applying for the positions of judges,
That's right.
justices.
That's
I don't know
correct.
why. When I think the salaries are almost equal, you know.
It's only recently, ma'am, that the salaries have more or less caught up. So a lot of the prosecutors before had applied really early on and their applications got processed. And yes, you're right. The attrition rate of the prosecutors is pretty high because a lot of them, well, there's a prestige in becoming a judge. You know? And that's very attractive. Although I have to tell you, ma'am, I've met a lot of prosecutors as well who really, whose entire inclination is to remain as prosecutors, to be the best prosecutors they could possibly be. For me, I think the long-term solution here is really in the law schools. We have to start telling the people who are taking up law that being a prosecutor is a good thing. And on that note, in fact, I understand there's a Judicial Academy that was planned for prosecutors, and I think that will go a long way in establishing the prestige as well of being a prosecutor in the Philippine prosecutorial system.
Next question, Mr. Secretary. In light of the decision of the Supreme Court in the DAP case,
Yes, ma'am.
declared to be unconstitutional,
Yes.
in your honest view, do you think President Aquino, once he steps down, can be charged criminally or otherwise? And also, you know, taking in consideration the operative fact doctrine.
As a matter of law and my appreciation of law and the facts as I know them, I don't believe he should be charged precisely because of those operative fact doctrine and good faith. And in addition, he doesn't fall under the category of an author, proponent, or implementer of this program. What the President did was merely exercise his discretion under the Constitution to augment projects using savings. And that's a completely allowable act on the part of the President, as it is a completely allowable act on the part of the Supreme Court Chief Justice and the Senate President. I don't think he should be charged, but in today's world, he probably will. So,
Yes. Probably he will. He will be charged. We don't know. Supposing he is charged, his defense of good faith can only be raised, you know, as a defense.
that's correct.
Because under that operative fact doctrine, the author, the implementer, and the proponents acting in good faith can be acquitted.
Yes, ma'am.
Okay. So next question, Mr. Secretary. Do you always agree with the decisions of the Supreme Court?
No.
Can you cite? Of course. I also don't agree in several decisions of the Supreme Court. Can you cite one or two decisions wherein you could have dissented if you were there?
I think that decision, the first decision that came out, I thought was wrong. You know?
The DAP.
Because there was a...
Why, Mr. Secretary?
For the very same reasons that were enumerated in the resolution after the decision. The resolution after the decision, to me, was more correct because, among others, there was a mistake on the part of the Supreme Court in believing that an item in the GAA is the same as a budget allocation or an allotment class. No? And I think the Supreme Court rectified itself in the resolution that came out subsequently and said after an MR. They rectified
So
it.
the resolution on MR bothers you because under that resolution, the authors, implementers, and proponents, if they acted in bad faith, can be penalized. Is that it?
Well,
the resolution.
No, the original decision, ma'am, if I remember
Because in the
correctly.
original decision, the good faith or bad faith was not mentioned.
No,
I think
in fact, in the first decision,
that was a good decision as far as you are concerned at first.
no, ma'am.
Not yet, because the DAP was declared unconstitutional. At any rate, we will no longer evaluate that
Yes,
decision. So, to my question, one or two, another decision wherein you could have dissented.
I can't think of one of recent note.
There are recent decisions like the case of Enrile, the case of Jun Binay, about condonation.
Condonation. Well,
do you agree?
No, ma'am, I don't. I think there
Anyway, condonation has been abandoned,
Exactly.
but the application is prospective.
Yes.
So you and I agree.
Because
Okay.
at that point in time, when the case was filed before the Supreme Court, there was established doctrine, and the established doctrine is by virtue of a string of Supreme Court cases.
Aguinaldo, Garcia,
Yes.
Garcia Sr.,
Yes.
Salalima, and Pascual.
Correct.
The first case.
And therefore, the Sandigan Bayan should not have been chastised for relying on those decisions to
Court of Appeals.
a court of appeals, ma'am, for relying on those decisions, because decisions of the Supreme Court form part of the law of the land. So, since the Court of Appeals is not the highest court in the land, they had no choice except to rely on case law. And the case law at that time said that condonation was a valid concept. It's only the Supreme Court really that can change it, and that's what they did. But
In other words, from now on, condonation will no longer apply.
No longer.
Okay. What do you think, Mr. Secretary, is the most disastrous decision ever rendered by our Supreme Court?
the most
Maybe you were still a law student, you were not yet born, but then you have been reading Philippine reports, Iskra, etc. The most disastrous. In America, there is also a counterpart, the most disastrous decision in America.
I can't think of any specific. Ma'am, I have to tell you that my inclination really in law is more civil law than anything else, because of my father. So in the field of civil law, there's a decision rendered by the Supreme Court that talks about vicarious liability on the negligence of hospital personnel being attributed to the hospital itself. No? And in that particular case, the Supreme Court relied on United States jurisprudence. And I thought that was incredibly wrong, because we have our own law on quasi-delict and negligence, and therefore there could not have been any reliance on any U.S. Supreme Court cases. For me, and since I'm focused on a lot of civil law cases, for me that might qualify as one of the more disastrous decisions of the Supreme Court.
I think it is the decision in Haveliana, if you remember.
This is
Haveliana declaring
Political law
that,
question.
yes, the Constitution, 1970
That's right.
Constitution, has
yes.
become
I think Lanzac versus Garcia and Haveliana.
upon ratification by those people from barangay who just raised their hands.
That's
For
right.
what reason, I
That's
don't
right.
know. Anyway, how about in America? What do you think is the most disastrous decision the U.S. Supreme Court has ever rendered? Which caused the civil war between the North and the South.
I think that's the decision which said that slaves did not have the right to vote. If my memory is correct, I think that's
Yes, the
that will
case of
qualify.
Fred Scott, the Negro, during the time of
Abraham
Chief
Lincoln.
Justice Taney. The decision was Negroes cannot be considered as citizens of the United States under the federal Constitution. Anyway, the warning is there. Thank you very much, Mr. Secretary.
Thank you, ma'am.
So good luck.
Salamat po. Thank you so much to everybody.
To be interviewed, Your Honors, is Sandigan Bayan Presiding Justice Amparo M. Cabotahitang. Assistant.
Good morning, Madam PJ Tang.
Good morning, Your Honors.
Ready for interview?
Yes, Your Honors.
Yes, so may request Attorney Cayosa to start.
Thank you, Justice Gutierrez. Good morning, Madam Presiding Justice Cabotahitang.
Good morning, Your Honor.
We have extensively interviewed you many times in the past, in 2011 and in 2013, both for the position of Sandigan Bayan Associate Justice and later on for the position of Sandigan Bayan Presiding Justice. And so it has been 2 years, a little over 2 years since you assumed the helm of the Sandigan Bayan. And I came across your inaugural message, and rather than asking you about what you have done in the past, may I just quote from your inaugural message, and perhaps you can give us some insights on how you have accomplished what you set for in your inaugural message as your wish list. So let me start with the first one, which is stated, and I quote, "For our court to stand united as a stronghold against graft and corruption," end of quote.
Yes, Your Honor. When I assumed the position of presiding justice, I have always reminded the officials and employees of the Sandigan Bayan to discharge its mandate of its mandate to be the vanguard of the people. That means it should be the very first one to set a high standard of public accountability. After all, it is the anti-graft court.
What can you say is your gauge if you have been able to make inroads or progress in this regard within the Sandigan Bayan?
Your Honor, in the Makati Business Club report, the credibility or trust rating of the Sandigan Bayan has increased by 7 notches since I assumed the helm of the presiding justice in the Sandigan Bayan, and I think this is a matter of record.
Second on your wish list is, and I quote, "For our court to exercise, enforce, and execute its powers more actively and purposefully," end of quote.
Yes, Your Honor. Again, I've always reminded my colleagues in the Sandigan Bayan that we should act promptly in cases, especially those that have been submitted for decision. And part of this was my constant reminder that we should always observe this saying that justice delayed is justice denied. And so I'm glad to say that as far as our records will show, some of the cases which have slumbered for years, which have already been submitted for decision, and which have not been decided then, have significantly been reduced.
Is this backed up by figures? Is there something that you can cite that would be proof that this has actually, the number of cases pending before the Sandigan Bayan has actually been efficiently addressed?
Your Honors, I don't have the figures right now, but at the top of my mind, what I can say is, based on, the Ombudsman itself came up with a report that the conviction rate of the Sandigan Bayan for the end of 2015 is higher than in the past year. And also, in so far as the clearance rate of the Sandigan Bayan is concerned, for now, we have 69-point-something% compared to 2014, which was only about 54-point-something%, so about an increase of 14 or almost 15%, Your Honors.
Third on your wish list is a time time-sensitive process. Could you tell us something about this and how you have been able to implement a process that you can anticipate when a case will be resolved in the Sandigan Bayan?
Well, again, Your Honor, is the constant reminder to my colleagues that we should be faithfully compliant with the constitutional deadline of resolving cases within 1 year from the time it is submitted for decision. And it does not only refer to decisions but also to incidents that are already submitted for resolution, like a motion to quash, motion to dismiss, motion for investigation, to get the cases going. Because if, for example, a motion for determination of probable cause is not resolved with dispatch, then that stops the progress of the case. So to get the case going, all these incidents must be resolved as soon as possible after they are submitted for resolution.
I recall that in the previous interviews that we conducted for aspirants for the Sandigan Bayan, there were proposals as regards the setting of time limits as to the resolution of matters pending before the court. Have you established, like for instance, the resolution of pending motions should be done within 30 days? And how have you been able to strictly implement such time limit?
Your Honors, just lately we had our court and bank session, and we all agreed, because we are in the process of submitting our revised internal rules for the approval of the Supreme Court, and we came to an agreement that all these incidents that are submitted for decision should be resolved within 90 days from the time they are submitted for resolution.
Fifth on your wish list is, and I quote, "for us to instill a sense of pride in every public servant who works for this court." End of quote.
Yes, Your Honor. Well, my reference here is not the officials, not only the officials, the justices and the officials of the court should take pride in what they do, but even the lowly janitor, because they all contribute to the whole process of administering justice.
And finally, you state, and I quote, is really a prayer that our court may be blessed with that constant power of discernment in all the cases laid before us, avoiding delaying justice, yet avoiding rushing to judgment. End of quote.
Yes, Your Honor. Again, this has something to do with the ideal that all cases must really be resolved with dispatch, ever conscious of the parties' right to speedy disposition of their cases.
So that brings me to my last question, Madam Presiding Justice. Wouldn't you consider that 2 years at the helm of the Sandigan Bayan may be too short a time within which to effectively implement the reforms that you have in mind, as stated in your inaugural message?
That may be true, Your Honor, but assuming that I get fortunately appointed to the position I am applying now, I believe that there are others still in the Sandigan Bayan who can continue with these reforms that I have started, and maybe equally good, if not better.
Thank you, Madam Presiding Justice, and I wish you well.
Thank you, Your Honor.
Thank you. Thank you, Madam Chairman.
Thank you so much, Attorney Cayosa. May I request now Attorney Mejia to continue.
Thank you, Madam Chairman. Good morning, Presiding Justice Kabutahitang.
Good morning, Your Honor.
My question, practically all the questions that I listed here were addressed by the questions of Attorney Cayosa, but for whatever it's worth, may I ask you one or two questions. Based on the goals you have set for yourself when you applied for the lofty position of Presiding Justice of the Sandigan Bayan, how much have you achieved in meeting these goals?
Your Honor, there are much things still yet to be done, but I am proud to say that from a scale of 1 to 10, I would say that maybe 6 would be an honest gauge of what has been achieved so far.
don't you think that leaving Sandigan Bayan now would hamper the goals that you have set for yourself in achieving those goals?
I don't believe so, Your Honor, because my colleagues in the Sandigan Bayan share the same goals as I do. And I'm sure even if I get appointed to the High Court, those who will be left behind would continue with the same goals, to pursue the same goals, Your Honor.
In an Inquirer News last July 24, 2015, you reacted to the Ombudsman's, or you allegedly reacted to the Ombudsman's accusation that the anti-graft court is delaying the pork barrel scam cases. What is your thought on this?
Well, Your Honors, the litigants and even the media who appear before our court can attest to the fact that the court, whatever division in the Sandigan Bayan, is always desirous of resolving cases with dispatch, and it will not and will never tolerate any delay or even an attempt to delay the proceedings in the cases, and that is why it's not correct to say that the Sandigan Bayan is delaying any of the cases pending before it. In fact, Your Honor, if I may say, we have set hearings for the plunder case that is pending before us thrice a week, and the lawyers are complaining, but we rejected any move on their part to cancel any of the hearings, because the court will and shall always adhere to the call for a speedy justice.
That was my final question. Thank you and good luck again, Justice Kabutahe.
Thank you, sir.
Thank you so much, Attorney Mejia. And now may I request again Attorney Guevara to continue.
Good morning, Madam Presiding Justice.
Good morning, Your Honor.
In your order of priorities, how important is your family?
Thank you for that question, Your Honor. Let me answer that question by saying this. When my children were still in high school, I thought of applying with the Court of Appeals. But one of my children cried. So I thought of a way how to balance my family with my profession. So I thought of applying with the Sandigan Bayan. So this provides the balance between family and work. So I always strive to strike a balance between family and work. But of course, at the end of the day, when demands for family call for it, as a mother, I would go for my family.
Pardon me if I misunderstood your statement. You said that you found more chances or more opportunities to have a balanced life with your work at the Sandigan Bayan compared to a situation where you would have been at the Court of Appeals?
Yes, Your Honor, because...
Why is that so?
Yes, Your Honor, because in the Court of Appeals, once you get appointed, you have to go first to either Cebu or Cagayan de Oro. So I will be physically separated from my children who were then still in high school. So to be able to so as not to be separated from them physically, I thought of joining the judiciary, where I could still work with the judiciary and at the same time be physically with my family. And that, the Sandigan Bayan precisely provided that opportunity, Your Honor.
I understand now. Do you have any health issues, Madam Presiding Justice, which may affect discharge of your judicial functions?
None, Your Honor. I submitted the requisite medical results as of the JBC, and I did, Your Honor.
Medical results show that you have this condition called atherosclerotic aorta. Can you enlighten us on what this condition is all about?
I'm sorry, Your Honor, I'm not, I do not really know, but my doctor said that there is nothing to worry about it, and in fact, he has not prescribed me any medication for this.
How do you cope up with stress?
Frankly, Your Honor, I do a lot of singing at home.
Singing.
Yes, and play badminton. That's those are my ways of de-stressing.
Have you ever said or spoken a cuss word or insulted an employee when probably you lose your temper because of the pressure of work?
I raise my voice, Your Honor, when I get to that point where orders consistently are not adequately addressed, but that is more infrequent than it is then it happens.
All right. As a justice of the Sandigan Bayan, you must be very, very concerned about building a culture of integrity in Philippine society. So, do you have any suggestions, or maybe you can give us a couple of measures that you have in mind so that we can build a culture of integrity in Philippine society?
Well, Your Honor, when one demands let me start by saying that one who imposes something must practice what that person imposes. So, to me, it should start from the head of office, because only then would that head of office have the moral authority to demand the same kind of exacting standard from the officials and employees of any agency for that matter. And maybe a constant reminder to the officials and employees that a public office is a public trust. And the constitutional mandate that every employee must at all times act with utmost responsibility, integrity, loyalty, and efficiency.
Do you have any religious beliefs?
Well, I am a Catholic, Your Honor. I go to church, I pray.
If a law which allows same-sex marriage is brought before the Supreme Court and is questioned on constitutional grounds, what would your opinion be on the matter?
Well, I go by the traditional definition of a family, Your Honor. A family is composed of a father, a mother, and a child. That is what we call a nuclear family. So, what is the purpose of marriage? Marriage is supposed to be for purposes of this one with procreation. And there can be no procreation if if the parties are of the same sex.
So you will vote against a law that allows that kind of marriage?
Well, at this time, I cannot say that I will vote for or against that. You know, perhaps it will require a more extensive study on what the correct position should be.
Okay, that was my final question, Madam Chairman.
Thank you very much, Attorney Guevara. And now may I request Justice Lagman to continue.
Thank you very much, Madam Chair. PJ Kabutahitang, good morning.
Good morning, Your Honor.
You have been the presiding justice of the Sandigan Bayan for a little over 2 years now. Why do you think you are now ripe to be a member of the highest court of the land? With your experience in the Sandigan Bayan, which started in 2012 when you were appointed as an Associate Justice and then PJ, and your experience in the Office of the Solicitor General.
Yes, Your Honor. I have been in the public service for almost 36 years to this date. 30 years were spent in the office of the Solicitor General, where I was richly exposed to the different fields of law. Criminal law, civil law, taxation, family law, and a good number of constitutional law cases. And there I learned how to write pleadings, be an advocate, appear before the court. I even appeared before the Supreme Court and argued some of the constitutional law cases involving the Republic. And given this experience, Your Honor, of almost 31 years in the OSG and 3 years in the Sandigan Bayan, I respectfully believe that I have gained the adequate tools that equip me to a higher calling, which is to be part of the highest court of the land.
Okay. With that answer, what do you think can be your contribution to the Supreme Court if you will be fortunate to be nominated and appointed?
Your Honor, it would be twofold. One, as a member of the court, to promulgate and enforce rules for the judicial reform or transformation, such as decongesting the dockets of the court. And secondly, as an individual magistrate, to render decisions, well-grounded decisions, and to resolve all cases with dispatch.
Okay. Now let's go back to your role now as PJ of the Sandigan Bayan. There have been reports that there is some members of the court as well as members of the staff are committing corruption. Now, what have you done to address this problem or to weed out these corrupt members of the court and personnel?
Your Honors, I have never hesitated to take administrative action against erring officials or employees of the Sandigan Bayan. More than a year ago, that was sometime in December, a security guard in the court purportedly requested or solicited money from one of the lawyers of one of the accused in the court, and I took immediate action by writing the Supreme Court to place him immediately under preventive suspension, so as not to prevent people from entertaining even the thought that corruption or any effort at corruption is tolerated in the Sandigan Bayan. We've also administrative cases have been filed against those who are claimed to have mediated or acted as middleman in an attempt to make improper disclosure of or premature disclosure of decisions of the court. And corresponding sanctions have been meted out on those employees who have been found guilty, of course, after observance of due process, Your Honors.
Okay, let's go to another point. What are your views on gender sensitivity? gender sensitivity. Now, if you are appointed to the Supreme Court, how would this principle affect the performance of your functions?
Well, to me, Your Honor, gender sensitivity simply means that we treat everyone, irrespective of our gender, equally. And equal opportunity, irrespective of gender.
So it will have no effect whatsoever.
No, Your Honor.
Okay. Now, considering that we have interviewed you several times in the past, the latest of which was in 2013, my last question is, can you give us a strong reason why we should nominate you again for a slot in the Supreme Court?
Your Honors, I have been in the government service for almost 36 years. And this service in the government was done with dedication, honesty, and utmost integrity.
So, did you receive any award while you were in the Office of the Solicitor General in connection with the performance of your work in that office?
No, Your Honor, because in the OSG, the ASGs normally do not receive any awards. It's the solicitors, because sometimes we do it during anniversaries. We select the most outstanding lawyer and another for the admin staff. I don't recall if we had one for the ASGs, Your Honor.
I see. So on that note, I have no further question for PJ Tang. Good luck.
Thank you, Your Honor.
So thank you very much, Justice Lagman. My first question is concerning the question of Attorney Guevara on gay marriage. When he asked you what will be your opinion if this kind of scenario reaches our Supreme Court, and then your answer was sort of you will study the matter first, okay?
Yes, Your
okay. So may I remind you that readily in our Constitution, it states that the state recognizes the sanctity of family life and shall protect and strengthen the family as a basic social institution. And under our family code, there is a provision that a marriage should only be between a man and a woman. Can you not just decide this case on the basis of the Constitution and the family code?
Your Honor, since you have reminded me of this constitutional provision about the protection of the family, and as I have stated earlier, my definition of a family is a father, a mother, and a child, then
you can decide outright.
Yes, Your Honor, then maybe I will strike that down as unconstitutional.
Yeah, the basis of the U.S. decision is Equal Protection Clause. Justice Kennedy stated that sort of all Americans are equal, and that therefore they should enjoy equal rights, equal benefits, equal protection, and the fundamental right to enter into the contract of marriage. Supposing this case is before you, can you also anchor your decision on the Equal Protection Clause and what are the requisites of classification? All Filipinos are equal, whether they belong to the transgender, bisexual, lesbian, and what's the other one? Gay. They are Filipinos. So what is your idea about this? Will you also rely on the Equal Protection Clause, just as you will rely also on the constitutional provision which I read a while ago?
Well, the Equal Protection Clause, although discrimination per se is not prohibited, but what is simply disallowed, as far as I can recall, is unfair discrimination. I don't think the the right to equal protection would tilt the balance in favor of this gay marriage, Your Honor. I would rather go for that constitutional provision about protecting the sanctity of marriage. And I still go back to my definition that a marriage should be between a man and a woman.
But these four classes of people are also Filipinos. It was not their fault or their fault to be like them. They are all Filipinos, covered by the Equal Protection Clause. Anyway, that would be maybe a debatable matter. When the issue reaches the Supreme Court, you can either dissent, concur, or what. Anyway, you stated a while ago in answer to the question of Attorney Guevara that sometimes you raised your voice. Well, at this stage maybe, considering my experience, I'm older than you, a retiree. The moment you reach that kind of emotion, you know the advice. I learned this in the National Judicial College when I took up the art of conducting trial. Declare a recess, go inside your chambers, drink a glass of cold water, and face the mirror. And eventually call both lawyers, the opposing lawyers, and then give them a good dressing down. In that way, you will not be, criticized with respect to your judicial conduct. There should always be judicial temperament. Okay.
Thank you for the advice, Your Honor. I will take that to heart.
Justices of the Sandigan Bayan are actually trial lawyers, just like the RTC judges, but then you are always in a division, and your concerns are only basically graft and corruption cases. Has it occurred in your mind that maybe to expedite disposition of many cases now pending in Sandigan Bayan, that each justice, of course there should be a law, should be allowed to conduct trial singly, alone. So the three of you will be handling graft and corruption cases individually. What do you think? Because this is the view of some sectors.
Well, Your Honors, maybe that is a practical solution to speeding up the disposition of cases, but we have to contend with the fact that under our internal rules, all three justices must hear.
If there is a law, you will do away with the internal rules. Do you think that law, if there is a law that way, do you think there is wisdom in that?
Actually, now, Your Honors, under our latest amendatory law, Republic Act 7660, only two justices, the presence of only two justices will now constitute a quorum. So it will be easier now for us to proceed with the case. To hear cases. Unlike before, if there is one absent justice, we could not proceed. We have to borrow another justice from another division to complete the quorum of three justices. But under the current law, the presence of two justices is needed to constitute a quorum.
So in your view, a single Sandigan justice should not conduct a trial alone. Okay?
Yes, Your Honor. Yes.
Okay, of course, you are aware of Rule 65, expanded the jurisdiction of the courts. This is, the power of the court to determine whether or not grave abuse of discretion for lack of jurisdiction has been committed by any court. Do you remember where this expanded jurisdiction originated?
Well, this is found.
Eventually, it's now in our Constitution, but it's not in the Constitution of America.
Frankly, Your Honor, I don't. My only basis is Section 5, Article 8 of the Constitution, which now grants the Supreme Court expanded jurisdiction, which means that the judicial power of the Supreme Court does not only extend to deciding actual controversies involving legally enforceable and demandable rights, but also extends to acts of government officials which are alleged to have been committed with grave abuse of discretion.
So this latter power is what we call judicial review.
Yes.
If you remember the case of Madison, Marbury versus Madison, 1803. Do you remember that in the College of Law?
I don't remember it anymore. I'm sorry.
President Adams signed the commission of Marbury as Justice of the Peace of the District of Columbia. But President Jefferson, Secretary of State Madison, refused to release the commission or appointment. So this expanded jurisdiction, actually we copied from America, this case is the source of that. Anyway, oh my goodness, there is a warning already. So thank you very much, PJ. Good luck.
Thank you, Your Honors. Good morning.
Last night po,
Last to be interviewed, Your Honor, is Congresswoman Quinchona Cruz Gonzalez, CBAC Party List. Congresswoman Gonzalez.
please sit down and good morning.
Good morning, Your Honors.
So, to expedite matters, it's almost 12. May I request Attorney Cayosa to start?
Thank you, Madam Chairman. Good morning, Congresswoman Cruz Gonzalez.
Good morning.
I had the occasion to go over your career as a lawyer, and you graduated as valedictorian in elementary and finished law in San Beda.
Yes, ma'am.
But you had to take the bar twice. What happened?
During the first time, Your Honors, we reside in Malabon, and in 1990 there was this. Of course, there's a perennial flood problem in Malabon. However, that particular year was extraordinarily high. So I had to get out of the house and make my review somewhere else. It's not that I'm making excuses, Your Honors, for that failure of mine, because I know even in extreme circumstances I should have done more. But that's how it is, Your Honors, and I'm very glad that I was given another opportunity, and in the next year I was able to complete my bar.
You were admitted to the bar in 1992, and you became an associate of the Gunigundo Law Office, after which you were connected with People's Law Office. And then you joined the OSG, which you served for 12 years. Why did you decide to resign from the OSG after 12 years?
Your Honor, it is primarily because of the demand also of motherhood. I have two small kids at the time, and I felt that I need more time to spend with them. And we all know for a fact the load in the OSG is very time-consuming, I would say, and that's why I decided, Your Honor, to prioritize rearing for my young kids then.
Notwithstanding the rigors of family life, you did not stay idle because, in fact, you applied for the judiciary. That was the first time you applied in 2005, but you withdrew your application in 2007. Why?
Your Honor, I did not withdraw my application then to RTC. I went through the process of application and the interview and the submission of all the documents. I wasn't shortlisted then, Your Honor.
Okay. Yes, you were interviewed on May 17, 2005, but we do have a letter here dated February 13, 2007, where you stated you were withdrawing your application without prejudice to future application. And that was shortly before you became a member of Congress representing Sibak.
I'm very sorry, Your Honor, that I cannot recall that particular instance. My apologies to the council that, with all honesty, I cannot remember that anymore.
At any rate, this is your second application for the judiciary. Why have you decided to apply directly for the highest court, for a slot in the highest court, and not go through the appellate courts? I know this is your last term in Congress.
Yes, Your Honor. I was also asking myself why, and I just found myself believing that that's a dream that I should pursue. I may not have the experience of the other applicants, but the richness of the experience that I had in my stint in OSG and in Congress particularly had made me decide to pursue my dream, and even in this early.
You have been interacting with politicians for the past 3 terms. Wouldn't you find it difficult to make a shift from being a legislator in the legislative branch to the judiciary, considering that you have ties with political personalities?
Your Honor, I was given the opportunity in our party list to make principled stands in every issue. Yes, I maintain relationship with my colleagues, but in terms of issues and our advocacies, those are matters that that cannot be changed, and I stand firm on what I believe, Your Honor. And I'm very glad that part of the democratic process is for all of us to accept whatever view that we may have on different issues. As we all know, there are as many views and opinions as there are congresspersons. But I have my colleagues have known me to make my stand known, and I stick with what I believe.
What would you consider as your field of expertise in law?
I would say, Your Honor, family. I was given the opportunity to host a free legal counseling program back in 1992 to 1997, and even now, I'm also given the opportunity to host another radio legal counseling program. And basically, the questions that we receive from our people has something to do with family, and because of that, I would say, Your Honor, that that will be my field of expertise.
What would you advocate for if you are given a chance to serve in the High Court in order to improve the administration of justice and the judicial system?
I'm very glad that as it is now, Your Honor, steps have been made by the judiciary to improve our services to the people in terms of legal concerns. Perhaps more courts have to be created, as what we do now in Congress, and appoint the best candidates for this position, especially in the provinces, so that the matters that have to be resolved concerning the issues of the people has to be resolved speedily, Your Honor. And more than the remedial, I would say there's a need for us to further strengthen our information campaign on legal matters. In my stint as a radio counselor, legal counselor, I noticed that most of the problems can be resolved even with the litigants not going to the courts. I'm very glad that we have this arbitration and the dispute resolution, which is being espoused by the courts, because there are times when two parties have just to be guided and has to be advised and to be given the opportunity to articulate and made known their positions. And I realized that actually there's always a middle ground. There's always a room for compromise. In that case, if we strengthen this arbitrary or this voluntary or rather the avenue of being able to compromise and talk, I think that will really ease out the docket problem of the courts. And if I may also add, Your Honors, concerning the creation of new courts, that it may be also expedited by, for example, money claims and accidents or torts and damages issues, that they will be given a shorter period of time in order to resolve this issue so as not to add more to the dockets of the courts.
Thank you, Madam Congresswoman. Now, may I know, when was the last time you read the Code of Judicial Conduct?
That would be a few years ago, Your Honor.
Now, if you recall, there is a provision on the impropriety, and that a jurist must always avoid even the appearance of impropriety. This is my last question. If you become a member of the High Court, what would you make a conscious effort to do to ensure that you would avoid not just the impropriety but any appearance of impropriety?
Your Honors, even now, while I'm in Congress, I observe that particular code because I'm still a lawyer, even if I'm a congressperson. There are many people who want to talk to me about certain things, and there are certain times that I have to be out of sight just to avoid them from influencing me or from suggesting something that should be done. I make my own decision, and I'm privileged that in my party list, we are guided by certain moral rules, and by that we abide by it, and that precludes us from being influenced by others, Your Honor.
Congresswoman Cruz Gonzalez, and I wish you well. Thank you.
Thank you, Your Honor.
Thank you,
Thank you so
Madam Chairman.
much. Again, Attorney Cayosa. May I request now Attorney Mejia?
Thank you, Madam Chairman. Good morning. It's still morning. Congresswoman Cruz Gonzalez.
Yes, sir.
I'm just curious, are congressmen or representatives like you allowed to go into business or exercise your profession?
Not to exercise our profession, Your Honor, because the rationale being we might influence the courts when we exercise our profession while we are members of Congress.
What about going into business?
I am not involved in business, Your Honors. Although there is no clear prohibition on that matter, but I deemed it fit for me not to be engaged in business transactions, especially so that we are exposed to so many kinds of people because of our of the position that I have now. So to avoid any entanglement with or any impression that I may be favoring someone, I'd rather not engage in business.
Actually, Madam Congresswoman, the reason why I asked that is because your annual income tax return reflects that you have business income.
That would be for my husband, Your Honor. My investment is only in the family corporation. I'm not involved in the handling, in the decision making. I just invested some of our savings to the family business, Your Honor.
Okay, because in your annual income tax return, your husband has a separate column for his own income, and in your own column, you have your own personal business income, for which you have actually availed yourself of itemized deductions, which a compensation income taxpayer cannot avail herself of. In any case, let me go to another point. What is the basic advocacy of your party list, Congresswoman?
Your Honor, that will be anti-corruption. CBAC stands for Citizens Battle Against Corruption.
So what institutional reforms do you have in mind that will ensure that appointments to the judiciary are immune from influence by the appointing authority?
Your Honor, I still believe in the integrity of the appointing authority over the positions that has been given to him by the Constitution. With regard to what institutional reforms, for one, I think the FOI bill can very well serve that purpose, Your Honor, because the people will now know exactly who are the candidates, who was appointed, and for what reason that person was appointed. In FOI, that enabling law, if it becomes a law, will empower the people to know exactly what the government is doing with regard to transactions, and not only transactions, but also as it fills up even sensitive positions in government, Your Honor.
Thank you. That was my final question. Good luck, Congresswoman.
Thank you, Your Honor.
And thank you, Madam Chair.
Thank you so much, Attorney Mejia. May I request now Attorney Guevara to continue.
Thank you, Justice. Good morning, Congresswoman.
Good morning, Your Honor.
Do you find any logic in the existence and composition of the Judicial Bar Council and Bar Council?
None, Your Honor.
There's no logic?
I'm sorry. There's logic to it. I'm sorry. I didn't get it the first time. There's logic to it. Because of the sensitiveness of the positions that has to be filled up, a number of people whose integrity is unquestionable should be in the Judicial and Bar Council in order to go through the requirements, go through and sift through probe into the character even of the person who's applying for a specific position. That's why I believe the Judicial and Bar Council has been created and has been placed in the Constitution for that purpose, Your Honor.
All right, what about its composition? Do you find any logic in the composition of the Judicial and Bar Council?
Yes, Your Honor. A representative from, of course, the Supreme Court, a member of the Academe, a private sector, member of Congress. This is a fair, good representation of who would be members of the Judicial and Bar Council, because not all applicants come from a specific agency of government or a particular branch of government, and there should be a good number of members of the Judicial and Bar Council who are experts in said fields, so that you will be able to gauge if a particular applicant who comes from a particular field of expertise is qualified.
Why should there be a representative from Congress or from the Executive Department? Isn't that more of putting pressure or influence on the selection process?
Considering the so-called political patronage that can be a problem, Your Honor. However, I still maintain that the presence of a member from judiciary and or rather from from Congress and from the executive has to be maintained because all of the agencies, the major branches of government has to be represented, Your Honor, in the selection process because many of the vacancies are not only for judiciary, but there are also most of the vacancies are for the executive department, and the presence of an executive member of an executive is very crucial also, Your Honor, depending on what position and the qualifications. That's why to maintain a balance, there should be a member from the executive, the legislative, and the judiciary, Your Honor.
Correct me if I misunderstood you. Are you saying that there are some non-judicial positions that the JBC will have to screen applicants to?
My apologies, Your Honor. That is not my intention. It's just that I maintain that there should be a balance of views, a balance of opinions in very sensitive positions in government, especially in the judiciary. The executive branch has to be represented, the legislative has to be represented, the judiciary has to be represented, and the private sector even has to be represented, Your Honor.
As a member of Congress, you represent, you're a member of the party list system. Have you participated in any congressional investigation or congressional inquiry, supposedly in aid of legislation?
Yes, Your Honor, as a member of Congress and whose advocacy is anti-corruption, there were issues in the past concerning corruption that I personally have attended and have participated in, Your Honor.
Can you be more specific? Can you cite maybe some investigations, congressional, in aid of legislation where you participated?
Your Honor, prominently was the case of then Ombudsman Merceditas Gutierrez. That was in the 14th Congress where I belong to the minority group, and as part of the minority group and whose advocacy is anti-corruption, there were issues concerning corruption. So it is but fitting for us, and it is expected of us to be part of that probe, Your Honor. Personally, I just wanted the Ombudsman to answer the allegations, to give her the opportunity to answer them, because allegations and complaints were thrown at her left and right, and I believe that was a good opportunity for her to answer and to make known what the real score is and what the position of the then Ombudsman was.
All right, could you please tell us what legislation that investigation led into?
The investigation led into the conclusion that she should be impeached. And as the articles of impeachment was being prepared to be submitted to the Senate, that was the time, if I'm not mistaken, Your Honor, that she resigned.
Would you consider impeachment as a legislative act in the sense of congressional inquiries being in aid of legislation?
Considering that it is a right and a mandate, rather a power mandate, authority mandated by the Constitution to Congress, yes, Your Honor.
Are you aware of any congressional inquiry of late which has led into an actual passage of any law?
There were amendments to the Procurement Act, if I'm not mistaken, Your Honor, because of the issues concerning corruption then and now. The members of Congress have seen that there were gaps and loopholes in the existing Procurement Act that gives a little allowance to officials to perhaps contemplate doing a misdeed, Your Honor. That's why that was one of the laws that I remember has been amended for that purpose, Your Honor.
Okay. Do you think that in the judicial process, occasionally spiritual beliefs come into play in the determination or resolution of cases?
We cannot separate, Your Honor, one's belief, especially religious or spiritual belief, in one's thought process, Your Honor, and then especially in the decision making. So I would say there is really it has some factor, Your Honor, in the thought process that is translated in the decision making.
Is that something that we should allow?
In my opinion, Your Honor, why not? Especially, we are in a Christian nation. And as a Christian nation, we have been brought up with sets of values, Filipino Christian values and beliefs, that are not harmful at all. In fact, Christian belief and values teach us, or Christian teachings teach us to uphold justice.
So the Bible can be used as a citation of authority in deciding or resolving a judicial case before the court?
Perhaps, Your Honor, not entirely in deciding the case, Your Honor, but as perhaps an opening statement just to put a guide on how things should be, or something that is relevant to the case, but not necessarily in the decision part itself, Your Honor. Something like a guide, something like an encouragement, something like a word that will inspire even.
In family law, we use the term psychological incapacity as a ground for declaring a marriage null and void. Do you find that concept a useful one?
In the present changing times, Your Honor, I believe the framers of the Family Code deem it fit to not to define psychological incapacity and lift it exactly from the canon law in order to give way, or at least an opportunity for some couples whose situation may not fall under legal separation grounds or annulment grounds or declaration of nullity grounds, some allowance in order to severe the marital ban. But of course, since we have put enough guidelines and enough safeguards, Your Honors, considering that a petition like that has to still to be brought to the court, and the court will still weigh the position of both parties before even severing the marital ban. I think, Your Honor, that should very well find its place in our family code law.
Isn't that what one situation where one's spiritual beliefs actually come into play very strongly?
It can, Your Honor. The fact that it was lifted from canon law.
Exactly.
Yes, it has some religious influence in that aspect. But yes, the Bible says that it is not His perfect will for man and woman to separate. But if in case that there will be separation, that the Bible also allows, not because God likes it or He is advocating for it, but because of the human nature, then He provides, or the Bible has provided, that a divorce can be made based only on unfaithfulness.
Not all Filipinos are Catholics or Christians. Some do not even have any spiritual belief at all in God. So don't you think that we should altogether discard that concept and probably have a law on divorce with specific and concrete grounds for that kind of legal process instead?
I believe, Your Honors, that even those who have no concept of God as we Christians or Catholics have, they still have this set of moral values which they observe. And these moral values are very beneficial in shaping them. Now, with regard, Your Honor, to the passage of a divorce law, I am personally not for it, because the existing law are enough, are sufficient in order to address problems concerning spouses. That's the reason, I think, Your Honor, that the framers of the Family Code have lifted psychological incapacity as a ground from canon law now to Family Code law in order to give some allowance for others who may not have the specified grounds provided under legal separation and annulment provisions and the declaration of nullity of marriage provisions. They will still have a window of opportunity to finally sever their marital bond based on psychological incapacity.
My time is up, Madam Chairman.
Thank you, Your Honor.
Thank you very much, Attorney Guevara. Now may I request Justice Lagman to continue the public interview.
Thank you very much, Madam Chair. Congresswoman Gonzalez.
Yes, ma'am. Good morning, Your Honor.
Now, Congresswoman, can you tell us what attributes or training do you have which made you think that you are now highly qualified to be nominated and appointed to the Supreme Court?
Thank you, Your Honor. My experience with the OSG has helped me a lot as a lawyer in terms of not only arguing for a particular position of government, but also in writing of pleadings. We have been trained by very good mentors, Your Honors, and I'm very privileged to be under such mentors. And my experience in Congress have placed me in a situation where, because it is very interpersonal, I talk to our constituents and deal with them almost every day. And there were those who came to me because of some legal battles that have long been fought in our courts. And balancing the legal experience to my interpersonal skills, Your Honor, and knowing exactly what our people need in terms of attaining justice, I think, Your Honor, that would be my best attributes.
Okay. What was your ranking in the Office of the Solicitor General when you left that office?
I was already Associate Solicitor, Solicitor 3, Your Honor.
So that is Senior Solicitor?
Yes, Your Honor.
Equivalent. You did not reach the rank of ASG?
No, I did not apply anywhere, Your Honor.
What are your thoughts on gender sensitivity?
As Vice Chair of Committee on Women and Gender Equality, we have seen improvements, Your Honor, in gender sensitivity issues. For example, if you have noticed, I mentioned chairperson or congressperson rather than congresswoman or chairman. We are very sensitive with regard to addressing our colleagues because we want the women to be empowered, and we are gradually succeeding in making this possible. In fact, I had the opportunity, Your Honor, to attend a conference outside of the country, and I have seen that we are more privileged than most of the women in other countries. Of course, there's still a long way to go because there are about 65 or less than 70 legislators who are women, and we are 292. So it's still a small portion, but then, Your Honors, we have seen the gradual increase. When I was there in last 14 Congress, we were about 50-something, and now in 16 Congress, we're about 65.
Okay. As a politician since 2007, is there any occasion in your life as a member of CBAC, which force you to give up your principles in life just to accommodate the wishes or requests of your constituents?
I mentioned earlier, Your Honor, that I am privileged that I am part of CBAC. we have our own set of values, unwritten at that, Your Honors. And because of this, there were no pressures exerted on me to bend my values and my principles. I'm very privileged that our president and our first nominee is of the same values that I have. And with regard to our constituents are also aware of the advocacies that we have fought for more than a decade. And they are also aware of the principles and the values by which we stand for, Your Honor.
What do you think is the greatest hurdle that should be overcome by the judiciary to gain fully the trust and confidence of the public?
I have seen, Your Honor, the latest survey, and in one survey, it appears that the perception of the people to the judiciary has decreased a little, and in one survey, it remains the same at 29%, if I remember it correctly, Your Honors. Now, to further improve, I think we should, or the judiciary has to be mindful of the speedy disposition of cases, because people on the ground had been complaining, Your Honors, that their cases have always been postponed, absences. But of course, there are certain things, I make them understand that there are certain things that are beyond the control of the judiciary, because remember, I'm telling the constituents and people who came to me that there's also another party concerned, and sometimes they're also the cause of the delay. But I believe, Your Honors, that the judiciary is now on the right track by implementing certain rules, like, for example, the deadlines that has been set in order to lessen the delay. And if the judiciary can see that what the opponents or the litigants are doing just dilatory tactics, then the court can just step in and stop it, Your Honor.
Okay. The 1935, 1973, and 1987 Constitution commonly provides that judicial power shall be vested in the Supreme Court and in such lower courts as may be established by law. In 1987, however, an additional provision was added, which states that judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been grave abuse of discretion on the part of the branch or instrumentality of the government. What do you think is the effect of this new provision in the 1987 Constitution?
Definitely, we can see additional work, Your Honors, but I can see the reason why it was given to the judiciary, Your Honor, because of the respect in the integrity of the court being the court of last resort. There are agencies or even bodies of or branches of government who might be exceeding the powers that has been vested upon them by the Constitution, and therefore, as a court of last resort, it is the judiciary which has to, if not correct, put them in the right place, Your Honor, so as not to exercise powers that have not been given to them, hence grave abuse of their discretion, Your Honor.
So, with this provision, some are criticizing that the Supreme Court is unduly interfering in the performance of the duties and responsibilities, as well as the operation of the branches of government. What are your thoughts on this?
I don't agree with the sentiments of the others, Your Honor, because yes, there are three branches in government in order to maintain the balance.
Yes.
And if it is not the Supreme Court, then who else will put these agencies in the right places in accordance with the Constitution? Because of the human nature that we sometimes tend to abuse certain powers, it is but fitting that the Supreme Court, the members of which are beyond reproach and very honorable, and the integrity cannot be questioned, then it must be the Supreme Court that should tell the agencies concerned whenever their acts are questioned if they have committed grave abuse of discretion. And if I may add also, Your Honor, there are only limited cases wherein the acts of these agencies can be brought to the Supreme Court, and that is only by grave abuse of discretion, Your Honor. So it is a very delicate task. It is a very important mandate, and it is a privilege for the judiciary to exercise that mandate, Your Honor.
Is it correct that the last time you applied for a slot in the judiciary was in 2005 for RTC Marikina?
If my memory serves right, Your Honor, thereabouts.
So what made you or decide to apply now for the highest court of the land?
Actually, Your Honor, when I reached Solicitor 3 in the OSG, and there were no other additional divisions then in the OSG, I don't see myself being promoted then in the ASG position, and the only logical conclusion then was to try our quote-unquote luck in RTC. But to be honest, Your Honor, it was more of an exercise of an option. I felt that my heart wasn't in it, and that's why now that Honorable Cayosa reminded me that I withdrew my application, then perhaps I had a change of heart then. Now, this is more actually of making a stand for myself that I can do this. It is a dream, and therefore I should pursue it. Nothing should hinder me, not even failures in the past, not even setbacks in the past. That Filipino spirit, the never to give up. And that is what I am telling myself now. And it is a privilege for me even to reach this point and to meet all of you. And with that, I can tell myself, I can do it. There will be no ifs and buts, what ifs in the future, because I have tried it. And whatever lies ahead, I leave it up to God. I have done my part. I have pursued my dream. And I'm very thankful that you have even accommodated me this morning.
Okay. On that note, I have no further questions.
Thank you, Your Honor.
And good luck.
Thank you, Your
Okay.
Honor.
Thank you so much, Justice Lagman.
Yes.
This question is related to the question of Attorney Guevara with respect to whether or not there is logic in the membership of the JBC. You see, when my nomination was being confirmed, there in the Senate, Congressman Fariñas said, we will abolish the JBC. Because as far as we are concerned, the Commission on Appointments still works very well, just like in the United States. His reason was appointments, should involve people, considering that the members of Congress represent the people. Therefore, the confirmation should revert back to them. And then, of course, I said there's too much politics, and you cannot expect nominees to be kneeling before every one of you, 24 of them. And then he said there is politics also in JBC. Why? Because the 4 members are appointed by the President, the Secretary of Justice, the ex officio member appointed by the President, the Chief Justice is appointed by the President. Only the representative from Congress is not appointed by the President, but by the people. So, according to them, the congressman present, the members of the JBC are under the thumb of the President. So I said, maybe this is a question of between two evils. So I choose the lesser evil. Okay. What's your thought on this?
The same way that we represent our constituents, Your Honor. Not all of our constituents can be in Congress. We represent them. Just like you represent different sectors, Your Honors. And because of that, yes, the President is there to appoint because that is exactly what the Constitution mandated for him to do. Unless the Constitution is amended, then we have to abide by what the Constitution says. And if I'm sorry, Kimanong Rudy po, but my view is we have to believe in the system. We have to believe in the person who's been elected by the people to administer and to fulfill the mandates given by the Constitution to him. And that is, one of them is the appointment of the members of the JBC. So I will not adhere to his views on the matter, Your Honor.
Still, you believe that JBC is better than the Commission on Appointments?
Because, Your Honor...
more effective, less politics.
Because of the composition of the JBC, Your Honor, you will not be appointed in that position if the President have not seen that you are an expert on the matter, that you are you have the integrity to dispense with the duties that has been provided by the Constitution. I believe in people, Your Honor. I believe in the system. And if every one of us will just say that let's just abolish this and abolish that, then what takes place? What should be placed in their place? What should be when they are replaced? With regard to the Commission appointments, the Constitution has also mandated them to appoint certain officials. But if we put every appointed official under their care, that would be also disastrous in the sense that we have so many functions to fulfill, Your Honors. And if all of the civil servants, if all of the even members of the judiciary has to pass through them, then I don't think they will be capable of doing that, Your Honors.
With respect to the mention of religion, because you said when you prepare or write your ponencia, if you are lucky enough to reach the Supreme Court, maybe you will also mention, your belief. You are a Catholic, right? You will mention passages from the Bible.
Not as the main point to decide the case, Your Honor, because we have existing laws. And I should base the decision on the facts. After weighing the facts, then apply the law. And I mentioned that a Bible passage can be there, I can write it there, just to inspire, just to set the tone, or perhaps provide a summary, or just to give something to think about, Your Honor, but not necessarily in the body of the decision, because the Bible has its place. And the laws of the land has its place also, Your Honor.
So you will decide your cases on the basis of the laws, jurisprudence,
yes,
the
Your
rules, and equity.
Yes, Your Honor.
Okay. So even our Constitution mentions God several times. Mm-hmm. We start from the preamble.
Yes.
We, the sovereign Filipino people, imploring the aid of Almighty God. So there's nothing wrong, I guess, if you mention once in a while, provided, as what you said, and as what I am saying now, the decision is based on the four aspects I mentioned. Anyway, how many laws have you enacted as a Congresswoman? As authored as a Congresswoman?
The dynamics in Congress is quite different, Your Honors. I have authored several bills concerning different issues, including amendment of VAUC, which now I intend to include even e-VAUC, the electronic way of committing violence against women. However, because of the dynamics of Congress, it has to have a counterpart bill to be passed in the Senate. And unfortunately, until now, even FOI, Your Honor, has not been passed in the lower house, and even though the counterpart bill in the Senate has been passed. So it has to be simultaneous, or if not simultaneous, one after the other, both houses should pass their own versions of a particular bill on a subject matter. Otherwise, it cannot become a law, Your Honor. So I have co-authored other bills.
As co-author, okay. How about, did you participate in the enactment of the RH law?
Yes, Your Honor. We were, I remember the debate was so intense at that time, and
Took you so many years.
yes, Your Honor. And it was very hard for us because we have to make a balance between what the constituents what the constituents' needs are, and of course what our beliefs are. So the pressure was also high at the time. But however, in my case, as long as in that particular bill there was nothing about abortion, I made sure that there was nothing about that, and also I even proposed some amendments in our collaborations with the principal author, Congressman Lagman, and finally we came up with a bill. It may not be acceptable to everybody still at the time, Your Honors, but this is where I see the importance and significance of the Supreme Court, and perhaps that encouraged me also, because even though this has been debated on for so many years and it has been passed only in the last Congress, there are still sectors who are not in approval of this bill.
Especially the Catholic Church.
Yes, ma'am. Yes, Your Honor. And that's why they brought this issue to the Supreme Court and asked the Supreme Court to intervene and make a ruling. And that's where I saw
And the Supreme Court
importance of the
declared
Supreme
it constitutional, except for a few phrases
Honor.
there. Okay. So, and there was a ruling by the Supreme Court that the Catholics' beliefs are respected, isn't it?
Yes, Your Honor.
And what the Supreme Court also held is that the drugs to be administered will not cause abortion.
Yes, Your Honor.
But don't you have any apprehension about it concerning this administration of drugs? Have you read the decision of the Supreme Court upholding that law?
I just heard, Your Honor, that the penal provision, if I'm not mistaken, was removed because that is in respect to and to uphold the rights of everyone to his or her personal beliefs, his religious freedom. With regard to that, Your Honor, I think in the exercise of our oversight function, we can always summon in a hearing a particular agency, the implementing agency, and let them, and we should guide them, and we should inquire rather into the implementation of that particular law, and therefore we can see if the drugs that are being given or the means by which RH can be implemented is something that is not within the contemplation of the writers of the law, then we can call their attention, because in that sense they are not in keeping with the existing law, Your Honor.
Yes, the basic apprehension is whether the drugs to be administered will cause abortion.
If it is
and
aborted
even the Supreme Court, is wary about it.
Yes, Your Honor.
Anyway, so thank you very much,
Thank you, Your Honor.
Congresswoman.
Thank you,
Good
Your
luck.
Honor. Thank you very much. Thank you po for the privilege.
The public interview. Mr. John.